Wouldn't qualify, unfortunately, for that anymore. But and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to receive award about my work defending the Constitution.
Okay. So you are the current president of the Criminal Defense Lawyers Group?
Yes,
Yeah.
yes, and it's the Georgia Association of Criminal Defense Lawyers. We go by GACDL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
Okay. And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals, appellate work in the Georgia Supreme Court and the Georgia Court of Appeals. The other half is trial work. I specialize in complex felonies, so anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
All right. And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement, and I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, around, I think it was late August, to represent him. He lives out of state, does not live in Georgia. Yeah. But so I've been his defense attorney since the time of indictment.
All right, so late August or September of 2023?
Yes, I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23, and then I negotiated bond for him, walked through the turn-in process, and began negotiations with the prosecutor.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers, there's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process?
Yes.
And those are the documents that are deemed to be false. They're
Yes, that's what he's charged with. He's charged with filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump?
No, I do not represent Donald Trump.
So your involvement in the case is just for Michael Roman?
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there were some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he giving you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but
Right.
everybody else may not.
Yeah, definitely.
Yeah.
So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents. The documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client, some of those have been deemed to be sensitive and that are not freely disseminated?
Yes, yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state, and nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning it is not our intent in any way to interfere with the criminal prosecutions, and so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order
Sure.
Protecting, so I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury, and I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury, and so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did, yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, the special purpose grand jury process, to bring in testimony and bring in witnesses from out of state. They issued a lot of target letters to people back and forth. That there was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in this special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity, and that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff, and then ultimately it was Mr. Wade, and there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
Right. And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order, and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term, a special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel, and I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first...
Just so you'll know why we're asking, the scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made some of these public, and there's of course a public, outrage or uproar or concerns about some of the alleged improprieties that you have brought forth, both within the in the system kind of what's appropriate conduct,
Right.
And also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes.
Right.
Or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I'm going to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to.
Right.
But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they paid between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it, and so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues, and so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts, if there's a conflict, and if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have, the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners. You've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it, and it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those, and so those are who I sent all of those.
It's over 50. I want to say 59.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only
or
2.
Only 2.
Only 2 had ever done
Fulton
it.
County is one of them.
Only 2. Well, yes. I'm sorry. It's 3 counting Fulton County.
Okay.
I did not send an open records to Fulton County on that because I already knew that they did it.
Is there a statute that authorizes that?
There is a statute, and I cite it, if I may, I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it. Let's see. So it's 15-80-20. And how I came to learn that is I actually contacted the Prosecuting Attorneys Council early on in this case, and because I was trying to figure out the legality of this. I did open records, and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what, I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18, the one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something like that.
What is that statutory rate?
I don't know it off the top of my head, but it is in the statute. I know that, like, District Attorney Willis, for example, I think it's around $200,000, and that's one of the top paid people. So most of the people are paid, somewhere between $100,000 and $150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually open records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending.
Because it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion? It's
controlled by the county, and I do know I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a long answer, though. Depending on who you are, in Fulton County depends on how your budget is approved. So, for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills. They do all of that stuff. So that's what happens at the coun's attorney's office.
Okay, the county attorney represents the county, is not prosecuting criminals like the DA does.
Correct. It's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole other issue. So the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically, they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget, though, so they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position, and I was surprised, so I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Her budget is granted through the Fulton County?
It is.
It's in a part of its budget?
It is. These special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog. And so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County Commissioners and asked for it.
When was that? Do you know?
I do, actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021 is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened. She was awarded that money September 15th, 2021, and she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the County Commission in September of 21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right? Okay.
That would be Exhibit A to that motion. Yes, okay. That's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay. So this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county?
Yes. Yes, it is.
Okay. All right. So what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help
right.
with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute, so the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval. Okay. So, I mean, the statute says it already. You know, when you were asking about changing statutes, I mean, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place, and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud? No,
not at all. And I watched the video. It's online, her speech, where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial, the DA's office or the county?
The DA's office. And I did bring the open records lawsuit, just in case you had any questions about that. So it was the county, and I can tell you when I filed it. Let me see. And we went back and forth, and you know, I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fani Willis.
He is, and he's also the one who went to the Board of County Commissioners whenever they needed funding. So, you know, if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office, and he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't, and I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it, we don't have to do it, I'm a constitutional officer. So their argument was, we don't have to comply with those statutes or those rules because she's saying she's a constitutional officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I've surmised is that was because those were staff members, and so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for Special Attorney General.
Yes.
Not Attorney General.
Special
DA.
counsel.
Okay,
Right.
counsel.
Yes. Essentially, that is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to comply with our state statute.
That they have, once they're awarded the budget, they can use that budget however. I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, their position is the county authorizes a budget, and she can pretty much has inherent authority to do it however.
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta?
Yes.
Okay. What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills, and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight, because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
So we have the code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires, if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that reviewed the time. So Ms. Willis reviews the time, and then it gets submitted to purchasing, and purchasing then pays it. And so that's the oversight, in her opinion. In the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. They don't actually look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
Okay. And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals, submit bills on itemized statement on what services they've rendered?
Yes, and the attorney general has very specific guidelines on that. What you can bill for, how you have to bill, and is told to remind. There's a reminder that this is public service. So essentially be judicious in your billing.
Right. You go voluntarily get underpaid to be able to help the public.
And a lot of people view it as public service, I think.
Are those bills submitted in tenths of? I do some billing, in my job, and it's usually tenth of an hour.
Yes.
Are there rules or guidelines or sort of standards of practice and how you bill?
Yes. So most law firms, I know because my husband used to work at a law firm, is 6-minute increments, and that's how most lawyers bill in the private sector. Public, it appears that most of them are in 10-minute increments. I know that's what all of the indigent defense groups, they all are 10-minute increments, but I've never seen anything above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
I honestly, I would have to go back and look. They were very small bills, though. They were making less than $2,000 a year, so they were small bills, and they were project based, which I think is also different. They would be hired to do a certain project.
If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal. There's a lot of guidelines in the county policies. So she would not have been able to hire him. It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies?
Yes.
He couldn't have been a direct employee of the district attorney's office?
Exactly. He
This
could not.
process circumvented those rules and ethical obligations?
Yes, it did.
Okay.
So
Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you, I'm sorry.
That's okay. No, that was the
Okay.
answer. So, if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes, and
Way more than he would have made as an employee.
way more, and also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Okay. Senator Dolezal, will you give us an example of one? I think we have one we're just going to pull
Okay.
up randomly, kind of.
Okay.
Is that an example of the type of invoices he would submit?
Yes, it is, and so
That's an actual one, isn't it?
that is an
Yeah.
actual one, and so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, Ms. Willis didn't approve it or didn't review it, at least as far as we know from the signatures.
But her chief legal officer did.
Right. So they would do that stamp, okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So he had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something that you would normally see.
All right, well, I'm noticing it lists the day and just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know. But that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges. The medical providers have badges. They all have the badges that they scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office, and I have been told that he had one, and those you would be able to see when he went in and out.
Okay.
But I was denied that.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed the county?
Completely. I mean, you would never see this. This is what I would call block billing. So one of them, for example, it's 28 hours over the course of 2 or 3 days. Team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting. And at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. And we've obviously never seen anything that he specifically has drafted. But I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting. Then it's got team meeting and argument prep. And then meeting with team. Most of his billing is meeting with team. team meeting, team investigation, team brain drain. He called it different things like that. But I went through, and I mean, that's the majority of the bill.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments, or
No.
more specifically, and does not really give a lot of identification of what's being done.
It gives pretty much zero, in my opinion, identification. I mean, this is not something that we would be able to submit to a client ever. I can't imagine. I mean, they would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. I mean, you have to be detailed in your bills, because that's accountability. I mean, that's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching, so I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Fani Willis that was approving these, either personally or through her designated assistants.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office?
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that there were, I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury, and later in November of 21?
Yes, it did.
Okay. Does it specify that that's what his role was going to be, or is there any way that's disclosed to the public what he was doing?
No, up at the top, I believe it says, let's see, it just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. The head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was originally in the emails that I talked about earlier, negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director, or chief assistant. She heads that unit, and she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff, and Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but I mean, no, he would not. But Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it was like $550 an hour or something, to investigate deaths in the Cobb County jail. So Sonia Allen was the chief. So when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Ms. Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed, part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Ms. Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families about how these inmates died. Mr. Wade was a witness and had to testify, and he had billed a lot of money, which I don't have a figure, but I've got the invoices, but he had billed quite a bit of money to Cobb County, but hadn't produced any documents, and so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything. But that's where...
That was some years before.
That was some years. I think it was in 2020, maybe.
So
it was right before
when
this.
did Ms. Allen get hired by the Fulton DA's office?
When Ms. Willis took office. So when Ms. Willis took office was the same time that Mr. Warren, who was Ms. Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job, and she was hired by Miss Willis to head the anti-corruption unit.
Okay. So from your documents you've produced and your news stories that I've read, apparently there were other special counsel that were hired by Ms. Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yes, so there's several, and so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three-lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Ms. Willis took office. They got contracts to do what's called taint work, which is essentially if for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privileged. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure? Right,
exactly. And one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those, so they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who are Mr. Wade's law partners.
So basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Okay. Not exactly prosecuting criminal cases then.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts, he was getting paid essentially from the law firm as well.
All right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes. So there's two other, on this case particularly. There's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases, so the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically. They do not currently have contracts. Yeah. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And
Same case. And he more experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO. Yeah. I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings. And
do you have
like
itemized billings?
Very much so,
and
yes.
What increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15 minute increments, okay. And So did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well-known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high-profile cases for the district attorney's office. I mean, I know her back from when, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high-profile cases there, but just very well-known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
investigations?
I might. Let's see.
Okay. You said Mr. Wade had about $700,000 so far?
Yeah. Oh, Miss Cross was under $100,000, I believe.
All right. So if she's under $100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. He has not billed in a while, so I was subpoenaed, or not subpoenaed, I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him, so I'm not sure if he actually did bill, because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests, but when they did respond, they were very limited, very small bills.
Okay. And your open records request was to whom? The Fulton County government, the commission, or the DA's office?
I did them to all of them, and once especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
Right. And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe, and the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
All right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting to see?
I believe the case. Right. I haven't received any documents, so.
Fairly recent filing you filed there, or that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a file stamped copy back, but it's now been served. But it was filed on January 30th.
Of 2024.
2024.
Okay.
And I have a copy, which...
I don't have that. If you would provide us with that, then we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can.
So what's the relevance to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade, and so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing, but Mr. Wade is always there. So that was one thing that I noticed, and I understand now that their response is that he sort of is like a case manager almost, so I guess that would be why he's always there, but I wanted to compare them and see. Okay.
I think I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly ones that showed the trips to D.C. We hadn't had but a couple of days to review all your documents, and I was I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with D.C. White House, 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I was not. I joined it, but I didn't litigate it. And the state said that they had to meet off campus, so because they didn't have a record of it, I guess you have to have a record if you go into the White House, and so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting, and they had to have someone who had some source or something to get them to agree to the meeting. But that's what. So the motion to compel was based on this entry, and this entry in response, they said they were meeting with the DOJ and someone with January 6th.
Okay. There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes, and we've tried to figure out what and who that was, because there was something happening at UGA Law School, and so we just assumed that it was someone that was there, and that's why they met there. But I don't know.
Do you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
I mean, the discovery, they've got a lot of our discovery involves the January 6th. I mean, a lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow. And then, there's one of the other things I did was I did open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at meeting with the vice president.
Okay, and so this is the access history. How does that work? The White House keeps records of anybody that comes in and has any kind of official meeting, for sure?
Yes, and my understanding is it's highly regulated who can access the White House, and so you have to apply in person or apply ahead of time, and then they give you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by, and they track you. And I mean, that makes sense. They don't want anybody lingering in the White House, but they keep that. And so they're called WAVE records, I believe is what they're called, and I'm not sure what that's an acronym for, but they're publicly available. They're open records.
And this record that's shown on the screen shows Fani Willis was a visitor with V. POTUS. I presume that's Vice President of the United States?
Yes, it was.
And what was the date of that back in, was that February sometime of 23?
February 28, 2023.
Is that before the indictment?
Yes.
Okay. Any further explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that I think it's Dickinson or Dixon, the mayor of Atlanta was also there.
Okay. We're going to take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in recess. 1 minute. We got a couple committee members on their way back. In order. We were reviewing the billing practices, the contracts that the various outside counsel had, and I've pulled up here one section of Mr. Wade's bill for the really early on in his involvement in the case. As I recall, it began on November 1st of 21, so this would be out of his first bill. I see on November 5th, prepare case for pretrial, 24 hours on one day. What do you make of that?
I mean, I thought it was astonishing that, you didn't sleep for 24 hours. I've been to trial. I'm sorry. I've been to trial and had to work long hours, but 24 straight. But we did question him about that at the hearing, and he said that that's when it was concluded. So how he explained it was November 5th is when the work was concluded. And so he had done that work up until then, and that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed was
Would have had to
concluded.
be between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day?
It had to be.
At least.
And, the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got it's like my husband couldn't represent someone who's adverse to me. Like my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting. So he's consulting on anti-corruption cases for the DA's office where his two law partners are doing the privilege review at the same time. That plus the 24 hours are the two things that really struck out to me.
So, but the only role he had was this prosecution of this election fraud.
Yes.
Okay.
Yes, the only role.
Okay. So when it says anti-corruption, that's the corruption. We're looking at election interference.
Yes, he's never worked on any other case.
All right. Let's see that other bill there, Senator Dolezal. All right, so here's another one, if you can see that okay. This is the one we put up earlier. It looks to be much more specific date-wise anyway than just, those 24-hour chunks like that. Okay.
Right. I mean, it's more specific, but it doesn't say what, like, just for example, team meeting and argument prep. Argument prep for what? I mean, normally when we do bills, we would say, argue motion to dismiss or argue whatever the motion is. Research, what are you researching? Researching statutory privilege, whatever it is.
Yeah. Now this one, he shows date ranges when it's over multiple days. Like down at the bottom, 426 to 427, 18 hours. Right. If I'm reading that right, or 16 hours. But on that previous one, he just has one date, 24 hours.
Yes.
Okay. And you say these are approved by Fani Willis. By contract, she has to approve these billings.
Yes, she does.
Okay.
And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, the county, in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break, though, and I have an answer to one of your questions earlier. I just wanted to clear up. You had asked me when the special purpose grand jury had convened. I looked. The state filed a response. So this is D.A. Willis's response that was filed on February 2nd. They wrote on
This response to your motion to disqualify?
Yes, sir.
Okay.
Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury, to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole, the cases are about attempts to disrupt, because obviously Georgia certified Biden as the winner, and he got inaugurated, that following January, and this is years later we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring or attempt, depending on which section you're talking about in the charges.
Some of these itemized statements show drafting.
Yes.
Did Mr. Wade draft any documents to your knowledge, or
No.
prepare any legal documents at all?
No, not that I'm aware of. And that would
Did
be.
he sign any pleadings as if he was the drafting attorney?
No, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it, and then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response, or their office's response, doesn't indicate that was ever done either.
And your experience when you were doing like your public defender work, that you were reviewed and they cut your time?
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because at that point I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just pick up right when they were going to the appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, I think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, they were regularly cut.
On Mr. Wade's contract, he was allowed to bill, he was capped. He could not bill more than $35,000 in any given month.
Yes.
Okay.
And that was not, so the original contract before the special purpose grand jury was started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury and then now. So he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times they were out of town. But so they re-upped the contract November 15th, and then it had a cap. But the cap was significantly higher. I mean, I don't remember the first cap, but it was not $35,000.
Here is a document you produced. I think you prepared this summary that shows all the payments that he received.
Either I did this, or this might have come from Fulton County purchasing.
All right.
Okay.
So that was produced to you from Fulton County as
Yes.
all the payments he received?
Yes, this was produced from Fulton County, yes.
And what's the total? Is that just, my eyes aren't so good. What that looks like 22 all the way through 23?
Yes, 22 through 23. So and so his first bill would have been paid in January of 2022. So he billed for time in November, December, and then you see those two bills. And so those were $15,000. I believe that was the cap. So in
Right.
January he was paid for $15,000 for work in November, and then in December he had work totaling $15,000, and he was paid for both of those in January.
That's why there's those top two invoices for $15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved?
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June. The order, actually. But what happened was they started picking, so it looks like they started picking the grand jurors on May 2nd of 2022, and they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm going to call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No, that he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County, so I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies, and he was actually just a solicitor, and solicitors is, because you'd said not everybody may understand the difference between solicitors and district attorneys.
We've got an ex-solicitor on this panel, so don't say anything negative about him.
So he can tell you all about it.
They prosecute misdemeanors only, right?
Yes, and in Cobb County specifically, they prosecute misdemeanors, yes.
Okay. It looks like he's pretty much hitting the maximum that he was allowed to under his contract?
Yes, most months he did.
Okay. And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task?
Always block billed.
Okay.
He never itemized bills, never was specific.
What were the caps for the other two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did. So they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts, and I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one, and Ms. Cross was at the hearing, and she said, I can just tell you right now I don't have a contract. So I had thought, I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't have one. So apparently right now Mr. Floyd and Ms. Cross don't have contracts.
Do you think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Okay. Does Mr. Wade have a current contract?
Yes, he does. I also think that, I think it may have been, I don't know if it's disclosure, but I can tell you that they've changed, since I started looking at this, they've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check, and since I filed this, none of them have come up. So I don't know if he's not being paid anymore, or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after. So, you know, they regularly came up, but now all of a sudden they don't.
Okay. So eventually you sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January, I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship, and they had been traveling, and he had been paying for a lot of that travel. So there were a couple different things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also—
You had figured that out through your financial records?
Yes, I had figured that out through my financial records, through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed, or I'm sorry, special counsel, because I found one where, and I think it's exhibit, let's see. It's exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval?
This is actually the county attorney. So
Okay.
this document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said doesn't. I mean, her filing, I at the break I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in parentheses, a state constitutional officer must be followed by an approval of the local government's board of commissioners. And she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval?
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare. I'm one of those.
Didn't follow what?
He didn't file an oath of office. Yeah. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who were district attorneys in other jurisdictions who took the case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it, so I did open records to the probate court, to the superior court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes. If you're going to be inside of a grand juries are highly regulated. I can't just go in a grand jury. None of us can just go into a grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret, and there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no public approval of these contracts. There's no oath of office filed. This is different, what's going on. We later found out that he had taken an oath, but nobody had filed it,
okay.
And the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney, their oath, when they are sworn in that position, says, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Ms. Willis sign her oath that swore she would not take any unlawful compensation?
Yes, she did that, and then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year, and you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100. And I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100, So people do take that pretty seriously.
So that would apply to Ms. Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County.
Okay.
So, and it's one of those.
That would include Mr. Wade, obviously, then?
Oh, definitely.
Okay.
And that makes sense because that's one of those provisions that's supposed to, be guarding against honest services.
Like anti-kickback statute.
That's exactly what
Hire
it's based
somebody as a vendor and they give you gifts in exchange.
Yes. And so they require that you disclose that every year. It's signed under oath. You have to file it with Fulton County.
So how'd you learn about this relationship between Mr. Wade? I think this has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes, that's
How'd you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Miss Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just, a lot of people said that, and so a lot of people were talking about that, and it was kind of surprising because it's not really he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? I mean, how do you have time to represent anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like, he had a law student working for him for a while, and then he had a first-year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their text messages. I mean, I was able to get get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say, I only want texts with this person. So if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from November 2021, and it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were meeting together, like there was that meeting with teams, or what? Were they billing for the same meetings as well? So
I looked at that. One thing is we don't have most of Floyd's. So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Ms. Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at counsel table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like, they won't pay for two people to sit there. And so I wanted to look at that. But they were both there in court that day.
What about the teams meeting where he billed for? Were either of them involved in that team, since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
Back to your uncovering the relationship.
Yes.
How did you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much money had been paid, because everybody in the case was kind of like, why do you have special counsel?
Case?
On this case, yeah. Like,
was Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's kind of unclear, like, what month. The testimony is very unclear as to when they actually. I have when they dissolved. I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization. But they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that, and I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it, because I wondered how that happened. But so that somebody published that, and I had done some more open records. And Ms. Willis actually called Mr. Bradley when I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation, and I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could, and I said, no, that's a conflict too. if you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, B.C. Chopra, he was there in court also. And then a friend of all of ours, who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad, and I took notes on all the things to ask for open records.
So what did he say was really happening when he said this is what's happening?
He said that they met at a judicial conference before. He was very specific that it was before she became DA, because that was one of the things that he couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in, it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married, and Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, the Wades were still married, and he essentially just left her after meeting Miss Willis and dropping the kids off at college. So.
And Bradley was Wade's attorney in that divorce action you're talking about? Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been,
Okay.
yes.
Okay.
And I actually don't know if he was still his attorney when he talked to me. I don't know if he was or not.
All right.
Because at some point, Mr. Wade represented himself, and then he hired a different lawyer. So I didn't know anything about the divorce at that time.
So Bradley did not like the way Wade had treated his wife.
He did not.
But he represented him.
He did not like the
Okay.
way he had treated his wife. He didn't like what was happening in the divorce proceeding, yes.
Okay.
And, I remember specifically him saying, I handle my business, things like that. Like, that I don't leave my wife without alimony. Because this, and we talked about it. Miss Wade had been a stay-at-home mom for, they'd been married almost 30 years. And literally it was right after they dropped their youngest off at college that he said, move out, And so we went through, I was obviously interested in, wait, what's happening? Walk me through this. And so he was telling me about the access cards, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and he told me, they met at hotels. He would go to her place. And I remember him saying, you need to find her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
did you later determine who that bestie was?
Yes, it was Robin Yeardy. It was not until sometime later that I determined that. It was very difficult to determine who that was because he did not remember her name. But
he knew her by sight?
He did.
Did he later confirm to you or identify who she was?
Yes. So I had sent him a couple pictures, or showed him a couple pictures of some other folks or names.
This was in January of 24, right
Yes.
before your motion?
It was. It may have even been after I filed the motion. It was around the time. It was either before or around the time, but it was in January. I had gotten some open records requests from the DA's office. They had a contract. Yep.
We just put on the screen
There it is.
some of the
Perfect.
text messages that you produced to us.
Yes.
This
yes.
is from your phone.
It is. And so
you're talking to Terrence Bradley, I see over there on the left.
Yes, and so when you see on the 14th, that one that's right in the middle that says file attachment with MIME type, that is a picture of her. So it doesn't show up on this, but it's actually, there's a picture of
So
Miss
while
Yeardy.
you're texting, you're shooting him a picture to see if he can identify Robin Yeardy?
Yes, yes.
Did he identify her?
He did, yes. He said, yes, that's her, that's the East Point. And he thought the apartment was in East Point. I later found out it was in Hapeville, but those are very
Right.
close in close areas.
So he knew they would meet at that apartment?
He did, yes. He knew all
Okay.
about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called Critical Mention. She has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. Right after Ms. Willis had opened the investigation in this case, that same week, he contracted a company called Critical Mention, which is a media monitoring company. They put a dollar figure basically on your media presence, and they give you these analytical reports. And they say, hey, you did great on MSNBC. That's $1 million worth of, stuff for your brand. The Fani Willis brand is doing well, or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity.
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent the letter to Raffensperger and Kemp about this case. Said, we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis' email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I'd never even heard of media monitoring. I didn't even know it existed. No. It was very shocking. But so I got some of the emails about this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlink to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Miss Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to this Critical Mention profile. It's a platform that you can log into and see, how am I doing in the media.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her, and I asked Terrence, is that her? Because I found out she had been fired or been let go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her information, get an address, and that's how we were able to narrow down where this Hapeville condo was.
Okay, so that's where basically Miss Willis and Mr. Wade would meet for their relationship.
Yes.
Yeah.
But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida, a lot of different travel. He said Belize. He specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records requests or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I subpoenaed credit card records, and then I actually subpoenaed the travel agencies that Mr. Wade used for some of those trips. He used, two of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas. I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one was to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis?
Oh, yes, the credit card statements. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Okay. And
so, there was no disputing.
Clear it was paid for by him on his credit cards?
Yes. Oh, yes.
Is this the document you gave us from the Capital One there?
It is, yes. And there you can see, so Clara Bowman is Mr. Wade's mom. So this trip, this was the cruise that happened October 31st, around that date. Mr. Wade paid for Miss Willis, Mr. Wade, and then his mother's plane tickets, and then also their cruise receipt. I think that one was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October, they took a cruise to the Bahamas, and this is from his financial records. He paid for this for both tickets?
Yes, this is from his financial records, and I tried to be, there were a lot of Ubers and things like that. I did not include things like that, I wasn't positive. I wanted to be under-inclusive, not over-inclusive.
Right. And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California.
Yes.
These are all from October 22 up till May of 23.
Yes.
Okay. This is a document you produced us?
Yes.
This summary, is this something we prepared?
No, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera?
Yes. Oh, yes.
Do either of them deny these trips occurred?
No, not at all.
So is this the impropriety, the financial impropriety of getting financial benefit from the job that he's paying for her way on these trips with money?
Yes.
That she's paying him and approving?
This is what I would call undisputed. Some of the other stuff on his credit cards, it looks like there's trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Miss Willis.
So back to you're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court.
Yes. And
he spills the beans on it and verifies it. Then you go get the documents to prove it's accurate.
Yes.
And you identify year to get him to say, yeah, that's the woman whose condominium they would go to?
Yes.
Okay.
And I developed it. You joke about my investigative skills. I've done public defense most of my career. At some point or another at pro bono, it's hard to get money for investigators, so I've learned how to do a lot of it on my own. I dig a lot on things. So, and I do like to use the Open Records Act, so I was able to do that and get a lot of information. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong.
Okay.
I didn't want to make any allegations that didn't have support. So I would regularly verify with him. And I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out, so he didn't continue this investigation, but he was involved in the investigation early on. And Mr. Bradley told him some of the same things that he told me. So, I was able to independently verify a lot of things, which to me, investigating is important, that the East Point location, that it was in Hateville. Robin Yeardy actually did quit. Mr. Bradley had told me about...
Was she forced to quit, or how'd that come about?
No, I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had she was outspoken about she didn't like some of the things that was happening in that office, and when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do because she did the communications, and so she quit after that, is my understanding.
Okay.
Based on her testimony and the allegations and all the pleadings.
Right. So after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this Trackhawk, Cell Hawk, what's it called, where you're tracking the
Yes.
location. You were mentioning to me earlier when I kind of got you off that employees can have it on their own phone if they want to, and she could have gone back and proven that they had not been communicating before he was hired.
Yes.
Okay.
So let me explain that, because there's two different systems, and I'm always learning new things about this, but cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The CellHawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. CellHawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hateville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff, I'll talk about the text in a minute, but what we had our investigator do was narrow it down. We got all the raw data, and we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which...
The location you're talking about is Ms. Yeardy's condo?
Yes,
okay.
It is Ms. Yeardy's condo, that area. So he was able to find, essentially, just to summarize a couple of things, where Mr. Wade would call Ms. Willis at midnight, something like that. And then all of a sudden, his phone would travel, and you can actually watch it. When you do the live CellHawk, the app, it's pretty cool. You can actually watch the phone travel, and it's pinging because you're using it. If you have an app open, your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home.
And this is before he gets hired in November of 21?
Yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the CellHawk data, but that's the summaries based on what we had him do. And again, we try to be very, very narrow. There were a lot of dates that it looked like it had happened also, but, maybe he was bouncing off a different location, and so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this you already kind of had the date on him?
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, the morning of the hearing, and obviously I'm kind of busy doing the hearing, we got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. I mean, it took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information. Yeah. But the other thing that I was talking about, so this is the CellHawk report, and heat map is just like how many times it's pinging, Heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage. The other thing I was talking about, just to make sure it's clear, so that's CellHawk. Cellbrite is a different program. Cellbrite, and it's Cellbrite. Cellbrite is a program similar to CellHawk, but it downloads data in the phone. So, like, this one is you pinging off of towers. It's geolocation.
Showing where you were.
Exactly.
At a certain time. Cellbrite
actually can get your texts, your pictures, your app usage, all of that stuff. So it's one of those things that if you want, if a defendant is threatening someone by text and they delete it, they'll take their phone and hook it up to Cellbrite. Cellbrite it makes what's called a forensic copy of the phone, but you can also limit the data. So it's a very expensive program. So not a lot of people have it. So when I have my clients use it, it costs a lot of money for them to have it done. But the DA's office has it. They have the software. They pay for it. You can find that in their open checkbook. The city of Atlanta police have it as well. But what you can do is you can copy cell phone. So, what I had mentioned earlier is
you have to have the cell phone to do that?
You do. You have to have the cell phone.
So what, did Mr. Bradley give you all his cell phone? Or
no.
How'd you get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. We cannot, I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to actually get someone's text messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start, and I said it started in April and someone else said it started in November, they have the ability. I don't have the ability. They have the ability to plug that phone into the Cellbrite and print out a report right. that shows all of the texts.
So Mr. Wade and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program, and it would have shown no communications between them.
Yes, and it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there was something that if they wanted to only limit it to, like, we want to prove that we weren't talking romantically in November, they could limit it to that.
So they could have actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest?
Yes, 100%. Yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do is get that geofencing.
Well, who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the texts inside the phone.
The words in the text.
Exactly.
But you were able to find out that they were texting each other prior to November 1st of 21.
Yes.
How did you find that data? Is that anything you've produced to us?
That is, so the Cellhawk data actually analyzes that. So you can see, we just summarized 2021. So approximately 12,000 interactions, that's voice and texts for the year of 2021. And again, remember, 2021, he didn't get the contract until November of that year. So most of 2021, he's not under contract. Over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront? We're not privy to what all came out in evidence at the hearings that you've had. Did you get either one of them to say, that's not true, we didn't really talk 12,000 times? Or? No,
what they did was they filed an affidavit saying that geolocation data is not always reliable.
Okay. Does that apply to Cellbrite data, though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost every murder case I've had in the last decade has had geolocation data.
Used by the prosecution against the defendant, right?
They use Cellhawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same, there's a trial going on, it's called the YSL trial. There's this same data being used in that trial, and our investigator actually analyzed it for them in that case. So, I mean,
for them, you mean for the Fulton County DA's office?
No, for the defense looking at that data. So the point is, they're currently using the same data in another courtroom to prosecute someone, but their defense in our case was that it's not reliable.
Okay. Got it. And did your Cellbrite data come in? The existence of the cell phone calls?
No. So the Cellbrite data, that would have to be voluntary on part of the DA to actually voluntarily.
So they could show you that to disprove your allegations?
100%.
Okay. Didn't do it?
No.
Neither Wade nor Willis?
No.
Okay. All right, so you've done your investigation. You've determined you think there was a relationship that had begun before he was hired.
Yes.
And after having met with Mr. Bradley, you began to prepare a motion to disqualify and to dismiss the case altogether, right?
Yes, I actually started the motion in September,
cell phone,
and then added to it.
Messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this?
Yes.
And was that because you didn't want to file a pleading that was inaccurate?
100%.
You wanted him to verify the accuracy of what you were claiming had happened?
I did not want to say one word that had not been verified.
Because he was the source?
Yes.
He's the guy that was his law partner and his divorce attorney?
Yes.
Who probably knew as well as anybody in the state.
They had been best friends also.
Okay. All right. And so let's pull these up, Senator Dolezal. When did you start? You kept these text messages somehow?
I did. So I actually, Mr. Bradley uses an Android, I believe, and so it was not easy to just download them, and I'm not the most tech-savvy person. There's a lot of texts that just went into things that I thought would just embarrass people and weren't relevant. So what I did was I screenshotted the texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept on and on for days saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam Abadi was the prosecutor.
Okay.
So he just kept saying, that where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete. Rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word. But, there were some that Miss Willis's daughter had failed out. Like, things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that.
So I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20, $30 and took 3 hours and I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed like when they're read, when they're viewed.
What were you, all right, so up there on January 5th at 9:50 a.m. Mm-hmm. You're asking, what do you, read the question.
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did, and I actually admitted. So at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it, and then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded, and then he responded that everything looked good. Because I asked, I said, I'm sending you this motion, I need you to look at it, and then he responded that everything looked good in it. Right. He actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received, and I didn't know that it wasn't really highly relevant to my motion, but he was like, oh, that's going to tip them off that I'm talking to you, and he did not want anybody to know that he was talking. He was very concerned about what
I'm going to let you just read through this chain.
Okay.
All right. We left off up there. Absolutely, it began when she was a judge in South Fulton. When was she a judge in South Fulton? She
became a judge in August of 2019, and I did an open records. I first asked. I first did an open records, and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the.
Who's both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So and it was in person, so I could narrow it down because of COVID. I figured out when COVID happened and when all the conferences went virtual. Narrowed down my timeline, so I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. Right. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Miss Willis went there because I was trying to fact check. And they said no. So I subpoenaed them, and they gave it to me. I also subpoenaed.
Was she in attendance?
She was. Where
was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from 2 different sources that she attended that conference, and that matched what Mr. Bradley had told me.
All right. So is that a part-time job, a municipal court job, a judge?
Yes,
okay.
It is.
So Wade could continue practicing law and do that on the side?
So she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most, because he was in the city of Marietta. I mean, he was he was a fill-in judge for that. That wasn't his.
Okay, so you narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green writing. What's
okay.
the next? If you don't mind, just sort of
read
us
of course.
Through.
It says, "Is this accurate?" And this was again on January.
So you're saying, "Is this accurate?" You're going over this brief and saying, "I'm about to swear this in court. Will you verify it's accurate?"
Yes.
Okay.
So at that time, I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12-something p.m. on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner?
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what? Multiple
reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in, to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
then you showed his text messages where y'all discussed it.
Well, at that point, that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I'd had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that, yes, he had.
Had told you that?
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not?
He acknowledged the relationship, yes.
Before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther King.
Yeah, walk us through that. What were the grounds that Phil...
particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that. So he was added on.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40-something people.
They had.
He was not even in that list of 40?
He was not.
And they didn't take, or they, as in Fani Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called Find Me the Votes, that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. And I mean, I have.
Was that because they cut deals with them, immunity deals, or?
Some of them were that. Some of them I just don't think she wanted to bother with.
And then she added to the list, though, people that were not even recommended, or
my client.
At least your client.
My client, yes,
Okay.
She added him, so he was one of the ones. So there were some people, and it's publicly available in that book, like Senator Graham, Loeffler, those Perdue, those people.
They recommended prosecuting them?
Right. She had considered prosecuting them and taken them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, why would you want to expand it? There's different ways you can go about prosecution.
Did you figure out why they add your client to the list?
No, but my allegation and my motion is that the bigger the case is, the more money that's made, and that that made sense to me. So for me to file the motion to disqualify, obviously, we had to have some type of a basis, besides all of the violations, and so expanding the litigation. Because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, follow me down the path, if you only indicted one person and it was narrow, you could try it in a month. If you indict 19 people and, 3 different essentially alleged criminal schemes, like I divided it up earlier, that you now have 3 years of trial. You've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special purpose grand jury to be indicted.
Okay. And you had the data to show that she was financially benefiting from the continued prosecution?
Yes. And so to answer your question, you were saying walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it, and at that point, the world is shocked. I mean, shocked, because nobody had any idea. This had been hidden. This was even hidden from her father, who she had testified she talks to 10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it. Mr. Bradley, that next weekend, he gets some calls about, he gets a call, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fani Willis?
Yes, and I've not gotten it. I've not opened records to it, but I have been told that Mr. Banks also has one of these special counsel contracts. Again, I have not opened records to that, not part of my case. But so he calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County, and he was upset. I talked to him. It was, I believe, a Saturday night, and I could tell he was upset by his text. I left my kids and went and talked to him because I was worried about him, and he took it as what he described to me as the first shot against the bow, that they were trying to figure out if it was him, and they were trying to silence him.
Trying
Gabe
to silence him?
Mm-hmm. And he said Gabe didn't say anything that threatened him. He just, out of the blue, called him, and he hadn't talked to him in quite some time. So it was out of the norm for him to call. So Mr. Banks called and told him that, was asking if he was the leak, meaning if he was my source. And Mr. Banks said that it was because he had seen a news article, and Mr. Bradley knew that wasn't the case, so he said, send me the news article. So he sent him some article that did not say he was the leak, and that put an end to it. But then the next day, Mr. Wade called Mr. Bradley's best friend and said to call, he didn't call Mr. Bradley directly, but told his friend to call Mr. Bradley and remind him of his privilege.
His attorney-client privilege?
Yes.
Who's the best friend? Can you tell me?
I'm not, he told me his name, and I'm not positive. I think I know who it is, but I'm not positive.
All right. So Wade calls Bradley's best friend, says, you better call Bradley, remind him he's got attorney-client privilege with me, and he better not spill the beans.
I do know the best friend works at a law firm called Beasley Allen. He told me that. He said his best friend's name, and then he said he works at Beasley Allen. And he was pretty upset about it, and it was the same day of Miss Yeager's birthday, so he didn't want to call Cindy, but he was upset, so he called me, and we talked about it, and we were both pretty upset about it, because it seemed, why...
Tampering with witnesses.
It just seemed like tampering, and it's just, it's just an uncomfortable position to be in, and all of us were kind of worried how the state would react to all of this. But at that point, it's
Did
still...
he interpret that as Miss Willis trying to intimidate him from revealing this affair?
Or Mr. Wade.
Okay.
He took it as intimidation, yes.
Right.
Because what he called it as is the second shot across the bow. Those were his words. So he said first shot across the bow was Gabe Banks, second shot across the bow was Nathan Wade calling.
Okay.
So that's how he interpreted it. But at that point, I had not disclosed him as the witness, as the primary source. So nobody knew that, and I was trying to protect him as much as possible, just because I knew he didn't want these calls. It's not something that you want. So they filed some motions to quash, and I had to
Quash what?
To quash all of the subpoenas, pretty much every subpoena that I had issued.
So after you file this motion to disqualify, I guess a hearing was scheduled?
Yes.
And
yes.
then you started issuing subpoenas to line up your evidence?
Yes.
That's when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
Yes. So, and let me walk through the timeline. So I filed this on the 8th. The next thing that happened was Miss Willis testified. I say testified. She spoke at a church on Martin Luther King Sunday, and was making some statements about why did they single out Mr. Wade. Didn't say anything about that we singled him out because he's the only one she's having an affair with. Did not agree to that. Instead said that it was racially motivated.
And the other two special prosecutors were white.
Yes.
But they were making significantly less money.
Right. And she even said, to the church, she even said that I'm paying them the same rate, which is not true. Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, one of my kids was listening to it and, said, come listen to this. And I listened to it and I was like, wait, that's not true. So that was one thing that she said that wasn't true. Also that it was racially motivated. She didn't say anything about, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm texting with Mr. Bradley, oh my gosh, are they going to lie about this? Like, it's on their credit cards. Like, I don't know what's going to happen here. And so then in the divorce proceedings, Ms. Willis had been subpoenaed to testify, and she actually invoked her executive privilege
Yeah, I
as the
remember
DA.
that. She wouldn't testify.
She would not testify. So then
They settled it.
Right, and then they settled it because because the judge said he was going to have to testify. So they settled it, and he did not have to testify. So at that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden the motions to quash started coming in. Right around that time, the state filed their response where they admitted to this relationship, but they put limits on it. So their response that they filed, I believe it was the February 2nd, I believe, February 2nd. So on February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a receipt from a credit card where she had paid for one plane ticket. So, it was a couple $100s on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis, I don't have a good faith basis, kept very harshly saying that I was making this up and nobody had told me this, and it was, gossip, and I was lying and I should be sanctioned. So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried because I knew they had called and all of these things, but I had to disclose him as a witness. And so at that point, I was still talking with Mr. Bradley fairly regularly, but that then changed.
Okay. So you're waiting on the judge to rule on your motion to disqualify?
Yes, sir.
In summation, the grounds for that are what? That this is improper for a prosecutor to have a relationship with the special prosecutor?
Yes, that it's a conflict of interest.
Okay. And that's because of the financial benefits, or just because?
Mainly the financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because the prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially motivated, talked extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is not allowed.
That's inappropriate conduct for a prosecutor?
Very much so. And there's case law on that. There's bar rules on that. So there were a lot of public speeches that were made along the way. And, they're you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements?
It was for a fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right.
So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I'd call it, where she's, calls me and, my client racist, and says, condemns their guilt. And then she also gave interviews to this book. I don't know, the timing was just, it was just nuts. But the book came out right around the time that all this was happening, and it's called Find Me the Votes. And
that came out in 2024, you're saying?
Uh-huh. It came out a month ago, if even. And she literally let the authors of this book in when she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that they had unfettered, behind-the-scenes access to her thought process and stuff. So, and she's talking about all of this, that they're guilty. But the big thing for the forensic misconduct is she's in the church speech, she's saying, and she says this in the book too, that God has told her to prosecute them. So the theme between these two things is that God told her to do this, and that she is doing the will of God by prosecuting our clients. And that is...
That's unethical.
In my opinion.
All right, so there was, I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which was that the day we started, 8th or 10th or something?
It did, and
it was the day session began, and all of a sudden these bombshell allegations come out, and I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case.
Right.
But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that,
as they were arguing the motion to quash.
I wonder, okay, so in that testimony, did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between them, a month or two here and there, whether it started, generally it was around March, is what Mr. Wade and Ms.
What are the
Willis.
consequences for an attorney to give sworn testimony that she did if you're Bradley, what is it, Yerke? Yerke, your Trackhawk data, your other independent verifications are found to be truthful?
It's a crime. It's a felony. You'd lose your license.
Okay.
It's perjury.
Same for Wade.
Yes. And we have rules that are one of the, outside of privilege and confidentiality, we cannot suborn perjury. So if I have a client who tells me I did it, I can't put them on the stand to say I didn't do it.
Okay.
I would lose my license over that. I cannot do that.
And Yerke came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together, and, they were very close.
Okay. And you had Bradley's text message that showed he confirmed that absolutely back in January.
Yes, and he had a lot of
Before-
details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text? What did he?
A garage door opener that Mr. Wade had a garage door opener, and then I've subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place?
To her place.
Okay.
Mm-hmm. Yeah, to her place. There were other things, just a lot of context, things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about that they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash so that there wouldn't be a record of it.
Okay. All right, so I'm a little puzzled by the legal standard. I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now, and I'm not the best person to explain that. My husband argued that part, but appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor, and we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety, and then actual impropriety is receiving money, like receiving money and not paying it back. And there was testimony about that. Ms. Willis came in and testified, and Mr. Wade did, that she paid him back in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
No,
receiving cash?
No, and we asked her where you got it. She said that she said she borrowed it from her campaign. So she said the original large sum of cash came from her campaign.
I think all of us up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not well versed in that area of law, but that is my understanding.
It's pretty black and white.
So she testified that she took that the majority of the cash she had on hand was from her campaign, that a loan she had given herself from the campaign. She was very clear about that. And then she also said that when it got low, she would supplement it by getting $50 back at Publix. But she's giving him, $4,000, $2,500, so large sums of cash. So, and there's no trail. Obviously, there's no record of any of that.
Right. In some of the documents you produced to us, there were a couple of IOTA trust accounts. Mm-hmm. Those were Mr. Wade's accounts?
Yes.
Okay. So he had more than one trust account in his law firm?
Yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes, and so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners, and then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account?
I think it might have been part of the reason that they dissolved.
That they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his own bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. I mean, he filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right, and he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay. So that's, does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes.
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money, so they're a lawyer trust account, and essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a
Personal injury case.
Personal injury case,
Right.
and you get $100,000, and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You've settled, you finalize the case, you send a settlement letter, you get the amount, and you have to put it in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that
All right. So
financially
sometimes
they wanted to.
attorneys may take a retainer
Yes.
up front and bill against that retainer. Say, you might do that on some of your criminal cases. Yeah,
Yes.
I'm going to take $25,000, I'm going to put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
That's exactly what they do with retainers that are refundable. So they would ask, $10,000 retainer, and then if this month I billed $1,500, I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract with Fulton County, should have probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that. But
ethical violation that can get you disbarred?
they highly regulate the IOLTAs. Highly regulate. I mean, the state bar, like there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain.
Okay.
But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon. You've been
Yes.
very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. Under our rules, we do allow at least one member of the minority party to participate. And Senator Jones, you're not time limited. If when the buzzer hits and you've got to go to court, you
Okay.
tell us, but I feel like we got at least 15, 20
You
minutes or
definitely
whatever.
do, and I'm happy to answer any questions you have. My court's at 115 in Fulton County, so, if I get in trouble, if you can call the judge, then I'm fine.
Number 9.
You got it.
I just wanted to go back to the issue about the conflict, because I think that's kind of what brought us all here to some extent. On one issue, in your brief, the most recent one that you filed,
The second one?
right,
Okay.
on page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath?
Right.
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed. And in and of itself, that's not, that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in an order. But I was trying to paint the entire picture and how I felt that it was relevant, and it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right. Now I was just kind of showing why I'm moving on to this next particular point here, which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that some kind of way this creates a conflict of interest. And, of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yes, page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47.
Ms. Merchant, we can't hear you.
I'm so sorry.
Just
I'm so
pull
sorry.
the microphone
Yeah,
just
of
pull it
course.
closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
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 Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case. Tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24, okay. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification, held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me. But essentially, to answer your question, that first of all is physical precedent only. So
Right.
yes, and we
But you did cite it.
and said
Right.
that it's physical
Yeah.
precedent only.
And you're using that as the basis, really, to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other
remember
defendants.
that.
Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical precedent only, and I don't remember the specific facts of that case, but it's not just a conviction. And obviously, the state wants it to be just a conviction, and we argued this extensively over 3 hours, I think, in front of the court, but it's also a personal stake in the prosecution, and that was an amusement. Prosecution in that case, that was a contingency fee case. So
That's
that was
correct.
Completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake and just bringing the case, because he can't have there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture act.
Correct, but they're going to get money if they win.
Right, but there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
that's the only way they get money.
Yes.
But they don't get money for bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still
Absolutely.
Make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, oh God, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm talking as far as this issue is concerned right here. When you use with worth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. Mm-hmm. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor. We want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taking place?
It's not in the trial, so it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal stake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleadings, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer. And we said no, we wanted a dismissal because he was not guilty. And that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case.
With a $5,000.
But it was going to end. It would be no more billing on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
Oh, I don't bill by the hour.
No, you're the one that's continuing to make him bill. He was willing to cut that off. You said, I believe that they created this case against my client so they can continue to bill. Well, he basically went out and said, I'm tired of billing. I'm going to offer a misdemeanor.
Okay,
and you said no.
Take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it in a little more detail. I tried to explain that there are really three classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in D.C. Then you see the electors. Then you see coffee. These cases could have been handled.
Ms. Merchant, we can't even hear you.
Oh, I'm so sorry.
Just pull it up right to you. Pull it to the edge of the desk if you have to, so everybody can hear.
Sorry. Okay. So how I was trying to explain it is I separate this down into three different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all three together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. they expanded it to include these 3 different classifications. What does that do? That means the trial is going to be a year. They can plea people out. They can plea Michael Roman out, they can plea this person out, they can plea people out, but they're always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone, bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation, because imagine if we just had, like you see in other cases, one defendant. You can limit the information to just that crime and that case. Or you could have 3 separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them to have 3 trials, because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited, physical or not.
Which one? Whitworth?
Whitworth. It says specifically that when the prosecutor goes up, Morgan, who is the person who's talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that was not a conflict, that was the prosecutor's decision to make. And you're saying, this is the case you cite, well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And so, therefore, the case that you cite is totally opposite than the situation that you're dealing with. How would you say that you have a conflict in this case? Based on this case, just based on this case. That was your first case that you cited in your brief.
I don't think it was actually the first case, but
the first was actually a federal case, but the first Georgia case you cited was Whitworth on this particular issue.
Right, on this particular issue.
Correct.
And again, I don't have Whitworth in front of me, and there's a lot of different facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got these financial disclosures where they're not being truthful. Ms. Willis is lying under oath, which is the same thing my client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately, drag out over the last couple months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is...
Who actually brings the case?
The district attorney. Well,
how do they get the case?
Well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So he's the one that he presented most of the witnesses,
How was your client charged? How are these clients charged?
My client was charged just in the actual grand jury.
Okay.
Yeah.
So grand jury.
Yes.
Okay, so we had a special grand jury, and then you had a grand jury.
Yes.
Who made this determination?
Well, yes.
They made a determination to bring charges, basically, to indict, correct?
Yes, and I.
So are they part of all of this?
No. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this. It is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident, and the grand jury indicted him.
So you're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the accusations?
No. No,
So the
and
grand jury.
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight.
Correct.
Definitely, but
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. And they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment, and then they vote, and it's a majority. So all they have to do is a majority vote, and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally, you've got a standard of 25%. I think there should be much more safeguards on the grand jury process, personally, but that's for another day.
So you went through special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3 already.
And they were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents, he's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. It was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers at the end of their career, and I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualification. So,
Oh, yes.
But you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills, yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral in that.
That's not surprising at all.
And he's going to a grand jury, and you say he's integral in that. Then why even say that he's inexperienced? And he's getting people to plead guilty. But basically, you're saying those are just lawyers that don't want to do anything anymore, and they just pled their clients guilty.
No.
I understand.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So he did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. Special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they've walked this case to this particular point. Very complicated case, I'd imagine.
I mean, that's something that we could debate. If walking someone through the grand jury, the special purpose grand jury is complicated or not. Asking questions, and again, there's a team of 10 lawyers. So
now there's a team of 10 lawyers.
Who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent. There's no adversary. There's no judge.
Once it became adversarial, you've had persons start pleading. And maybe more potentially, correct? Possibly. But we'll find out. But let me ask you this, though, because you were talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are, the office was basically shut down. It's a potential that the DA's office had actually basically shut down.
Oh, God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you hired 5 new inexperienced ADAs, they're not tackling this case. And also,
well, the inexperienced ADAs are not going to make $200,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job that you're talking about that you're going to hire with that, with the $1 million that you'd have paid him.
Yeah.
If that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just you're just saying the money you paid him, you could have done this. Because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth when persons were saying, well, they could have used this money for that. But that money was delegated for him on the short term project, so to speak. So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision, how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified and what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said it's totally unqualified. I did want to go into these trips. How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, is delegated to him because that contract can end at any time. She could say, hey, the contract, because he works at her pleasure.
Oh, yes.
So that contract could actually end at any time. That would be the point.
Yes.
On the trips, how much total were the trips?
About $20,000.
And I think it was about $17,059. But even if we say $20,000, what was the average cost of each one of those trips?
I don't know. Unfortunately, they did not provide all of the records, so I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you. Most of it was paid in cash, so there's no record. So I wish I could tell you, but...
Going by your slide, one was $3,335, one was $4,453.
Which one? Hold on, I want to make sure I'm clear on each.
You had 6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
Okay.
So the first one, Royal Caribbean, $3,335, Aruba, $4,453, and then we see the next one, and then the next 2. How would that compare? I mean, why is that so unusual on price points as far as trips are concerned?
No, I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had 2 cabins. His mom had a cabin. They had an oceanfront balcony. For the Bahamas, I think oceanfront balcony is probably upper middle, but I don't know that it matters. Flew comfort class. Not unnormal for a lawyer.
You know what maybe the average American spends on vacation?
Not this much.
You don't think?
No.
Have you looked?
No, I haven't, but I would imagine most of the Fulton County taxpayers would love to go on any of these trips.
Well, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief, because Forbes actually says that the average is about $3,700 that a person spends on a vacation.
For a single person or a family?
Family of 4. Well, at that time, they were taking 2 and 3 at the time.
That makes sense.
That's about normal.
Hold on. I want to make sure that's clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took his mother on.
2 adults.
2 adults, yes.
It's nothing extraordinary.
So So you said $3,700 for a family of 4.
Right.
That does not surprise me. For families that can afford to go on vacations, does not surprise me.
So it's basically what the average American would do.
So that's,
Yes.
this is half of that for 2 people. So you said $3,700 for a family of 4. This is for 2 people.
Right. It's just 2 people.
Right. So
Yes.
yes.
So it wouldn't necessarily be half. It's 2 adults. Bottom line is, it's not extravagant. It's not lavish, is it?
The law only says $100. So,
But it's not lavish.
That's one of the reasons I didn't include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas. I didn't include that. I didn't want to do the math, and I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year.
And so your
It's in my brief.
argument is that a person who makes $200,000 a year
Mm-hmm.
is actually setting up prosecutions to go on a trip that costs $3,500. That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm
in
not talking about
isolation.
isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip with $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your argument. If that's your argument, that's your argument.
That's not.
That's in the brief.
That's not our argument. So we did
What else
argue
is
for
in the
about
brief?
3 hours.
What else is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume, because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are
That's
on
what's
trips.
in the brief.
Yes, the ones
Right.
that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof, and so that's the proof that we have.
Exactly. That's what I
that
did.
person
Yes.
is doing all of this for that.
Right.
Okay.
Oh, yeah.
I
And
understand.
so what I included was what I had the actual hard proof of. And then some of it's attached to the brief. Some of it I got by subpoena. So some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted. And there were a lot of other receipts that I had that I did not know for sure if they were joined. And so I didn't include those. And I haven't talked
And you
about them
shouldn't,
today.
correct?
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. That. So my next question then becomes, going to conflict as far as his salary is concerned, just curious. Is it the amount of salary that you really creates the conflict? I mean, because we get stuck on money a lot. So is the amount of salary that is creating this conflict in your mind?
No,
Or
it's
is
the
just the
fact
fact
that
that he gets any salary at all?
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
Which we just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict.
Oh, I do, because of the Fulton County laws. The laws say that they
I
can.
don't understand the county codes, but I'm talking about as far as like what the case law says, which is
Oh, yeah.
what the judge is actually going to. If they're not hiding that or against the Fulton County ordinances,
They were hiding it, though.
do you believe that there's a conflict? If they brought it out and said, hey, we're dating, is it a conflict in your mind?
They only brought it out once I alleged it, and they called me a liar multiple times.
What I'm saying is that they brought it out, would it be a conflict in your mind?
If
Is it
they-
a conflict?
Here in a
And what would be the conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County's paying for and he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J, we wouldn't be here.
So then your client actually has no conflict because that would still exist. Your client has no hard conflict then. There's no actual conflict. It doesn't matter if you disclose a conflict. If you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you, and I have a conflict, and I'm going to go testify against you. Conflict is now over. Absolutely not. So, if you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict.
No.
So what you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict like that. You just couldn't. If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
I'm sorry, I don't understand your question to me. I don't know what you're
asking. You don't have
me.
a conflict if you're saying if she disclosed it, it would go away. Then there is no conflict.
No. I did not say that. I said we would not be here if that had happened.
Right,
That's
because you wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
But if she disclosed it, not the way you said it,
if
it was disclosed, it's disclosed now. What is the conflict?
The undisputed facts, the facts that we all, your side and my side.
How is your client harmed? That's my question.
Hold on. I'm trying to answer your first question now. So if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what could have happened.
What case law do you point to prove that?
Oh, the statutes. It's
no, it's not a statute. Not Fulton County statute. I'm asking for Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
No, and it's really not surprising, honestly, because can you imagine this happening? I mean, honestly,
it happens.
In December, would you have imagined this happening? I think most people wouldn't.
All sorts of conflicts are taken up by the Court of Appeals.
I can tell you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed, because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Is she paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
I don't.
He's
I wasn't
billing
there.
hours because he's prosecuting a case, correct? A
I
case that a grand jury indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I mean, words do matter when we say that she's not paying him in that sense. He's earning money for a case that he's in charge of prosecuting, that a grand jury indicted, and that's where we are.
You're correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender, and every government official that actually exists.
Employees,
100%.
Yes.
And that he is part of that process. And he is prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution. And you've said that.
I mean, he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says...
Which case? I'm sorry.
In Whitworth
Whitworth
v. State, it clearly says, the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay. Fine.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people, I'm visual. I like to see it. Do you mind?
You guys sit down, too.
Thank you.
While she's looking at this, we're going to wrap up here in a few minutes. I wanted to let the public know how you can get information to us. Each senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be calcert.inv@senate.ga.gov. INV, obviously, for Investigation Committee. So each senator, their last name, .inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee. And we are encouraging anybody that has input or information that might be helpful to us to provide it to a committee member, ideally to cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members. We don't have a next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for additional questioning after today, but I'm not rushing you. Take your time, read that.
Can it not be the first week of April?
Yeah.
Cobb County spring break, please.
That'd be fine.
Thank you. Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have, J-Tom, it should have struck with me. I remember this now. So this case, so J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk while you.
Oh, I'm sorry, I forgot the microphone. I'm not good at that, sorry. He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council, and I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it, and that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed, but in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue, and the judge pointed that out. That is post-trial. Post-trial, we have harmless error review. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens, and that's what you have there.
But in this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but they never discuss that because no conflict existed. And you're right, it is post-conviction, but bottom line is you really did not address the aspects that I was talking about when they say there is a conflict, and it's not me putting this case in talking about a conflict. It was the case that you guys actually did cite. With that, Mr. Chair, I yield.
Well, can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it and we're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
Adverse authority, but that's fine.
The oral arguments that we did, that was how the oral arguments started. So.
All right, so that line of question deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes. Yeah, there's no conflict.
Conduct.
Yeah, we're not talking about the conflict between defendants.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget and this contract, that he was not eligible to have been hired had he been disclosed because of, you referred to it as nepotism, but it's relationships
Yes.
with, and your complaints are of she's receiving a financial benefit of gifts of more than $100, which violate county policies.
Yes, county and state. So, and we attached that to one of the briefs, her return where she filed it under oath that says,
Okay.
I mean, it specifically says if you've got something over $100, you have to disclose it.
And
Here it
then-
is. It's so it's called the Fulton County Income and Financial Disclosure Report, and that says, and it says pursuant to Section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, for purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or is seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Okay. Keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment strategy to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book has now come out?
It is. It's. I don't think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published.
Is that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we allege that and argued that as far as forensic misconduct. It's very surprising, shocking, and I don't know that there's a ton of cases on it. But that book, also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Ms. Willis had prior to becoming DA. And so, it talks about that a lot.
Okay. Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or a payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
All right. Well, thank you for your willingness to testify before us, and the documents you provided. We'll need some time to analyze and review those, and again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to, and we might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted further meetings. The meeting is adjourned.